Welcome to today's coffee break briefing. Today I'm going to be talking about the question of whether a particular charge that you're looking at is a fixed charge or a floating charge. And I'll be looking at this with particular reference to the High Court decision of Avanti Communications from a few months ago. And these are the topics I'm going to be looking at. Firstly, looking at what a fixed charge is, and then I'll be moving on to look at what a floating charge is to see how that is different. And after that, I'll be spending a bit of time just to explain briefly why it is that insolvency practitioners need to categorize charges as being either fixed or floating. And then we'll move on to look at how we would do that before Avanti, and then from there, what Avanti has changed and what the implications are for you of that. So let's look at the first of those topics and look at what a fixed charge is. Now, I did actually cover this in a little bit more detail about 18 months ago in May 2022, and the presentation, the recording of that presentation is still available on our website. So if you want to go back and refresh your memories as to a bit more detail about fixed charges and floating charges and the nature of security, you may wish to go back to that. As you'll know, if you've been to more than one of my presentations, whenever I talk about fixed and floating charges, I never miss the opportunity to show a picture of a castle. And this particular one is Fairlie Hungerford Castle in Somerset. And it was extensively extended by Sir Walter Hungerford, its then owner, who, according to the English Heritage website, who was slightly coy about it, they say that he became rich during the 100 Years' War in the early 15th century, which doesn't exactly explain how he became rich, but I suspect that hiring mercenaries and plundering France would probably have been a big part of it. And if you were a landowner in medieval times, and you have to remember that English land law is very much based on how land law was, well, essentially when the Normans introduced their system of property to this country in the 11th century, a lot of the fundamental principles are still very much the same as they were. But if you were a medieval landowner and you wanted to raise money to hire a gang of bloodthirsty mercenaries to pillage France, and you wanted to transport them across the Channel to do that, you would be able to put up your property as security. And the way it would be done, this was how a mortgage used to work, is you would transfer ownership of your land to the lender in return for the money that you were borrowing. And as long as you kept your side of the bargain, you would be able to repay that loan in due course, and the lender would then reconvey your property back to you so that you would carry on as owner without any practical interruption in anything that had been going on. And the important restriction on what the lender could do really was that although the lender had pretty well complete ownership rights over your property while it was mortgaged to them, they weren't able to sell the property on the open market to whoever they wanted for whatever they wanted, while you were keeping your side of the loan agreement, because you were entitled to redeem the loan and get your property back. And there are still some classes of asset where you can take a legal mortgage in very much the same way by transferring ownership and having it reconveyed when the loan is repaid. Land these days is mortgaged by a legal mortgage or a fixed charge of some sort, and all mortgages are charges, but not all charges are mortgages. And the same principles apply as they did in medieval times, that the mortgage lender gets through the mortgage pretty well comprehensive ownership rights over the property, including the right to sell if the borrower is in default. I had to throw in this quote from Lord Macnaghten in the case of Samuel and Jarrah Timber, 1904, where he said in the course of giving judgment that he was sure that nobody ever understood an English mortgage of real estate. There are times when I think that's probably as true today as it was 120 years ago. So that's a brief look at what a floating charge, so what a fixed charge is. Let's move on to look at what a floating charge is and what's different about a floating charge. Now, a floating charge will be a charge over a class of asset, and typically it'll be something like all present and future stock in trade, or you will get the sweep up charging clause, which will be a floating charge created at the end of the charging clause of a debenture. It's usually clause 3. At the end of clause 3, there will be a floating charge on all of the assets, property and undertaking of the company, to the extent that that has not already been caught by other charges in the debenture. Key thing about a floating charge is that it allows the borrower to deal with the charged property without express permission from the lender. And by deal with the charged property, we mean that the borrower can do absolutely anything that they need to with the property, despite the fact that it is security for a loan. So if it's a floating charge on stock, the stock will come in, and if it's something like a stock of fuel oil, they can burn that oil, they can destroy it, they can, if it's stock of grain, they can grind it into flour and chuck away the husks. But they can do whatever they like with the property that's caught with the floating charge until the lender withdraws their consent. And that's what is referred to as crystallization of the floating charge, when the lender takes away their consent from the borrower doing whatever they want to the property in the floating charge. That crystallizes the floating charge. It converts the floating charge into a fixed charge. And as a fixed charge, it gives the lender all of the rights and powers and property interests that they would expect to have from any other fixed charge. So a crystallized floating charge is a fixed charge, which is exactly the same as any other fixed charge, except for one thing. And that is, in terms of the priority that is given, the priority of a charge is set by what category of charge it is at the time when it is created. So if it is a floating charge, it will always have the priority of a floating charge. Even after it has crystallized into a fixed charge, it will still, as a crystallized floating charge, it will still have the original priority it had when created as a floating charge. There's an awful lot of strange terminology around floating charges. So we talk about something that floats, then crystallizes, after which it descends and then attaches to the assets. And it's all metaphorical language, and I'm not sure it's terribly helpful. If I had my way, if I could rename a floating charge, I would call it a loose charge, because it is completely binary whether a charge is a fixed charge or a floating charge. And to my mind, the opposite of a fixed charge is a loose charge. But we are where we are. We're stuck with them being called floating charges. I'm not going to change that. I've already talked about crystallization, so I'll move over that particular slide. For this one, this is just a reminder that it is possible for a lender to take a charge, to take security over property that does not yet exist, property that the borrower will have at some point in the future, or may have at some point in the future. And that charge can be a floating charge, but it can also be a fixed charge, depending upon the circumstances. There's no conceptual reason why a charge over future property should not be a fixed charge. So that's looking at fixed charges, floating charges, and what the difference is between them. Let's move on to look at why it is that you, as insolvency practitioners, need to categorize charges as either fixed or floating. And again, you can go back to the coffee break briefing I did in May 2022 for more information about this if you're interested in looking at it further. But I'm just going to say very briefly, the main reason why you need to know whether a charge is a fixed charge or a floating charge is because of the priority of the charge. And priority is not straightforward. These are, in brief the main rules, which is that charges can be either legal charges or equitable charges, which is down to the circumstances in how they are made and how they are registered if they need registration. And a legal charge will almost always rank ahead of an equitable charge whenever the charges were created. Where you've got charges of the same category, legal charges or equitable charges, then the normal rule is that the oldest charges have priority over more recent charges. And where you have a register that shows ownership of the particular asset, particularly a register that sets the priority of competing claims in property assets, such as the land registry, then charges that are registered will take priority over unregistered charges. And the way that you register charges at the land registry can also affect their priority, and that reflects issues like whether they are equitable or legal charges, for example. Fixed charges will rank ahead of floating charges, and all of this can be changed by a deed of priority entered into, an agreement entered into between the lenders with the consent of the borrower. And it's not always this straightforward. I remember my lecturer at university setting us a particular conundrum where there were very, very specific circumstances, and the essence of it was that charge A had priority over charge B had priority over charge C, and yet charge C had priority over charge A. And essentially the lecturer was saying, okay, you guys sort out who has priority in a situation like that. Fortunately, I can't remember exactly what the circumstances were that created that particular conundrum, and even more fortunately, I've not yet encountered anything quite like that in practice, but it may just be a matter of time. So I said the issue is really about priority, and that is an issue about who gets the proceeds of sale when you sell assets that are caught by a particular charge. And I'll just zoom in on this particular diagram. The blue bar on the left-hand side, that's money that you have received from the realization of the asset, and in this particular case, hypothetically, it's £1 million that you have realized on the sale of this particular asset. And now you have to disperse that money according to who is entitled to it. The first block, which is the red block at top left-hand, that's £150,000 going to repay the holder of the first fixed charge on the realized asset. Moving along towards the right, the next red block is the same amount, £150,000 going to repay the debt owed to the second fixed charge holder. After that, we have the magenta strip, which is a payment of £50,000 going to the ordinary preferential unsecured creditors, and they're likely to be the employees. After that, there's a further £50,000 going to the other class of preferential creditors, the secondary preferential unsecured creditors. That's likely to be HMRC getting that. After that, because we have floating charges here, there is a prescribed part of the fund set aside for the unsecured creditors. In this particular case, the ordinary unsecured creditors get £123,000 from the prescribed part set aside for them. Then we have the holders of the floating charges being paid next. So that's the penultimate red block, which shows £100,000 going to the first holder of a floating charge. Then there's second red block, final red block, showing £100,000 going to the holder of the second floating charge. And then the final payment to the creditors is the magenta block on the right-hand side, which shows £250,000 going to the ordinary unsecured creditors. By good fortune, in this particular case, that, together with the prescribed part they have already received, is enough to pay the unsecured creditors in full with interest, which leaves the balance the small brown strip on the right-hand side then going to the shareholders who receive £27,000 in this particular distribution. So that's the cascade, the waterfall that shows the priority of payments and the difference in priority that you can get if you've got a fixed charge rather than a floating charge on a particular asset. Another way of categorizing floating charges is that some floating charges are qualifying floating charges, which give the holder of them the right to appoint an administrator of the company. I'm not going to say any more about that. Again, you can refer back to my previous coffee break briefing if you want to know a bit more about that. So that's dealt with the reasons why you need to categorize charges as being either fixed or floating, and it is very much a binary decision. Charge has to be either a fixed charge or a floating charge. It cannot be neither, and it cannot be to any extent both. It has to be one or the other. That there is no other options. So what we'll do now is we'll look at what the law was before Avanti and how we would have done that at that point. So in categorizing a charge as a fixed charge or a floating charge, you have to make a very binary decision on what can often be a very non-binary set of choices. That there isn't a clear dividing line between fixed charges and floating charges. I mean, there are some charges which are very clearly and unambiguously fixed charges, others that are very clearly and unambiguously floating charges, and then there are lots of charges in between who've got some characteristics of a fixed charge and some characteristics of a floating charge, and you have to decide which box to put those in. So yeah, you have to draw this line that separates where you're going to categorize charges as being fixed or floating, and you have to decide which side of this line any given charge may sit. And different people may set the line in different places. It shouldn't be like that. It should be objectively clear, and it should be that everybody looking at the same issues would come to the same conclusion. But Avanti was all about where that line should be drawn. And one of the things I really like about the Avanti decision is it's a high-level tutorial in this particular subject. The judge looked back over the previous decisions, and in fact, quite a number of heavyweight academic commentaries on those decisions as well, looked at all of that and then decided where the line should be drawn, not just in the case of Avanti, but generally speaking, what the judge was trying to do was to make it less likely for any of us to need to go back to court again with a similar situation, that it should be clear where the line is drawn. And as you'll know, if you've been to my coffee break briefings before, I never miss an opportunity to refer back to an old case. Here we go, Yorkshire Woolcombers from 1903. It is one of my favourite cases. The name is absolutely fantastic. And it is still the best definition that we have got of what a floating charge is. A floating charge isn't defined by any act of parliament anywhere. Floating charges were invented by Victorian businessmen and lawyers as a useful business tool. The definition from Yorkshire Woolcombers is still a really important one. It describes a floating charge as being a charge which is on a class of assets, present and future, where the class changes over time. Now that's a little bit vague because they don't say how much change you're looking at and over what period of time. But that, coupled with the next point, is perhaps a bit clearer. The next point is saying that the company may use those assets in the ordinary course of its business. And what those 2 points together are saying, in effect, is we're really looking at current assets here. We're looking at things like stock in trade that come and go, or book debt that come and go. And if it's a current asset, it's quite likely to be a floating charge on it. And that third point about the company being free to use those assets in the ordinary course of business, that's an important one. Watch out for that, because that is all about control. And the later cases have all been looking at that question of control and saying, how much control can a lender surrender to the borrower before the charge becomes a floating charge? And that's very much what this is all about. A couple of other big cases to look at. One is the Brumark case from 2001. And the Brumark case was really question for the court was, is a charge on book debts a fixed charge or a floating charge? And the court said it's a floating charge. It's not a fixed charge. Brumark was a Privy Council decision. It was a New Zealand case, and the Privy Council is the New Zealand highest court of appeal. The Privy Council judges are in the main the same judges as then sat on our House of Lords, now our Supreme Court. So where you've got New Zealand law being very similar to English law, as it is in this particular field, and where you've got the same judges ruling on it as would rule if a case in this country came to the Supreme Court, the House of Lords, you've got a pretty good idea as to what the law should be if the Privy Council have given a ruling on it. Key thing about Brumark is that in the 20th century, banks had cheerfully taken fixed charges on book debts in their debenture and had those charges recognised as validly constituted fixed charges on book debts rather than floating charges. Brumark overturned that and said that a charge on book debts is most likely to be a floating charge. And Brumark was followed up by Spectrum Plus 4 years later. That was an English case. That was in the House of Lords, which has the same standing now as the Supreme Court does. And in Spectrum Plus, the House of Lords emphasised this issue of control. If the lender has sufficient control over the asset, they will have a fixed charge on it. If they don't have enough control, they will have only a floating charge. And in the case of book debts, it would be very unusual for a bank to have enough control over those book debts for the charge to be constituted as a fixed charge. Well, what Spectrum Plus didn't do, having emphasised this question of control, it didn't really say how you assess that question of control, how much control is enough and how much is insufficient. So before Brumark and Spectrum Plus, we had this great grey area between fixed and floating charges. We had to decide where to draw the line. And the line was drawn very often in a position that was very, very favourable to the lenders, that it didn't require very much control over the asset to be regarded as enough control to give the lender a fixed charge. Spectrum Plus shifted everything in the opposite direction and seemed to suggest that the banks would need a high degree of control to be able to assert a fixed charge. Some commentators went as far as to say that unless a bank had complete control over the asset, they would have only a floating charge. And that was really the question then that came up in front of the court for the decision in Avanti. It was the question of how much control is going to be enough control. Does it have to be complete control, or is it something less than complete control? And how much less than complete control is enough control? Let's look at the facts of Avanti. It's nothing terribly unusual, actually. I mean, it does look unusual, but fundamentally, there's nothing terribly unusual about this case. There was a debenture which contained the usual battery of fixed and floating charges. There were lots of noughts after the numbers, which meant that the debenture had got many more pages than you will normally see. But fundamentally, it was a bank debenture. It contained the usual battery of fixed and floating charges. And the key assets that the debenture claimed fixed charges over were these. First of all, the HILAS 3 black box on European Data Relay Satellite C. And this was all part of Avanti's business of providing broadband communications. The other end of that was they had lots and lots of similar, or quite different black boxes and other hardware, a lot of plant and equipment back on the Earth. HILAS 3 was, of course, in orbit around the Earth. It was literally out of this world. The other tangible assets, most of them were at Goonhilly Ground Station in Cornwall. And the third asset that they were claiming a fixed charge on was paperwork. It was permits for the satellite and the ground station, mostly granted through Ofcom, although there were a number of international organizations involved in that. And crucially, but not unusually, the lending documents did restrict Avanti from disposing of those assets. They were quite detailed restrictions, but they were actually, in some cases, quite loose restrictions. There was an awful lot that Avanti was allowed to do without having to go back to ask the bank for consent to do so. And the courts, I think this is quite important, the courts took those restrictions at face value. They said, well, if they've been written into a contractual lending document and it's been signed and agreed by both parties, then we will assume that those restrictions are genuine restrictions and are there to be obeyed by the borrower and will be obeyed by the borrower. And that was actually quite important. So moving back to this diagram, which is trying to show where the line was drawn between fixed and floating charges, this is where I think I would put those three assets, the black box in the satellite, which is essentially just plant and equipment, the plant and equipment on the ground, and the consents and the licenses. They were somewhere between the lender having lots of control and the lender having some control. There was a degree of control that the lender had, but it wasn't absolute control. And the court said, yep, that's fine. That's enough control for the lender to have a fixed charge. And the judge said, well, I can see why you as insolvency practitioners found this really complicated and really difficult to work out. And you did exactly the right thing in coming to the court to ask about it. But I, as a High Court judge, have found it tremendously simple and straightforward to rule on this, having looked at every single case that has been decided over the past 120 years or so and read many of the academic articles. Anyway, the judge got it clear. He was very clear in his mind where it is. And from my point of view, I think the important thing is that this has shifted the dividing line between fixed and floating charges and has shifted it so that charges which previously I might have thought are likely to be floating charges will now clearly be fixed charges if Avanti can be followed. And moving from this one case to look at the cases that you're working on, here are the key points I think you need to know. That fixed assets can easily be caught in the fixed charge and the debenture. It will depend what the debenture says, but in principle, things like plant and machinery, licenses, consents, contracts, all of those can be caught by fixed charges claimed in a debenture. Current assets are still likely to be caught only by floating charges. The rule from Yorkshire Woolcombe was 120 years ago. That stood the test of time. That is still regarded as being a good definition of a floating charge. And the way that you should look to assess a particular charge starts by looking at what sort of charge the lender is claiming in their debenture. If it's a floating charge, if it's described as a floating charge, it will be a floating charge. If it's described as a fixed charge, it might still be a floating charge. If it's described as a fixed charge and it's a charge on current assets, it's probably going to be a floating charge, but you have to look to see, can the borrower use those current assets without the consent of the lender? And if they can, which is usually going to be the case in most bank debentures, then it's going to be a floating charge. So in terms of you preparing an estimated outcome statement where you've got a standard bank debenture, then you should be putting these realizations into the subject to a fixed charge category, things like land and buildings, plant and machinery, goodwill, intellectual property rights, contracts and licenses, assuming that all of those are shown as fixed assets in the business that was being carried on by the company you're dealing with. And in your estimated outcome statement, you should be showing these as floating charges where there's a bank debenture. Things like book debts, stock, and cash at bank should normally be the floating charge. That's the good news. This is now the bad news slide. And this is where we get a bit more technical again, I'm afraid. Avanti is a High Court decision. Spectrum Plus, on the other hand, is a House of Lords decision, which has the standing of a Supreme Court decision. And that's 2 ranks ahead of the High Court. Above the High Court, you've got the Court of Appeal, and above the Court of Appeal, you've got the Supreme Court. Spectrum Plus is up there in the Supreme Court. Avanti does give some much needed clarity, and as I said, what I really like about Avanti is this high-level tutorial that it gives in the difference between fixed and floating charges, and that is really, really useful for a lawyer. It also has the advantage of being very recent, so it represents the High Court's current thinking, we should hope, but it is technically outgunned by Spectrum Plus. Spectrum Plus is the senior decision, and so in theory you could find that similar facts, if brought to the High Court and given to a different judge, could give a different result, and a different judge could still choose to draw this line between fixed and floating charges in a different place. And could rely on Spectrum Plus more than Avanti, for example. And if you have 2 conflicting High Court decisions, you then need to go to the Court of Appeal, who would then have to decide between the 2 of them, or decide something else, indeed. So although it's very useful, very clear, very helpful, it's perhaps not fully authoritative, and that does mean that you will still, of course, be asking for legal advice in terms of the validity of bank security before you make a distribution in many cases, and you will still find that within the advice that you get from the lawyer, there will be the lawyer's favourite phrase, "It depends." And I think those are 2 great words to finish this morning's presentation on. I've covered all the points I wanted to. I'm 3 minutes over time. I've got a bit of time for questions. It looks like I've got a couple of questions here. So, Philip, I will deal with your question. Yes, fantastic question from Philip Sykes. Philip is saying the asset he still has some concern about is goodwill. Most debentures take a fixed charge for goodwill, but he questions whether a lender really has the necessary level of control to make it a fixed charge. Absolutely great question. I think that where Avanti has shifted the line of control, it does mean that it is going to be possible for the lender to take a fixed charge on goodwill. I think a lot will depend upon what restrictions there are on the borrower, the company dealing with the goodwill, disposing of the goodwill, but there are almost always going to be covenants in a standard bank debenture to stop the company from selling the goodwill without the consent of the lender. And I think that is going to be a good enough restriction. I think that will probably constitute a fixed charge on goodwill. So I think the likelihood is, after Avanti, that an asserted fixed charge on goodwill in most cases probably will be regarded as a valid, legitimate fixed charge on goodwill. Now, goodwill is very interesting because you could either take a charge on goodwill as an asset of itself, or you could actually drill into it and you could say that the goodwill itself consists of intellectual property rights, contracts, know-how, software, all sorts of other intangible assets. And you might find that some of those intangible assets, if you took a specific fixed charge on them, you might not have enough control on them for that to be regarded as a fixed charge, and might itself be a floating charge. But that's going to be very, very specific, and I think we're going to see lenders relying much more than perhaps they did in the past on actually having that charge on goodwill as a fixed charge and claiming it to be such. So thank you, that's really, really good question. And Chris, I've got a question from you. I'll have a look at. So this is Chris Tate is saying, if plant and machinery is movable, but the charge stipulated is caught by a fixed charge, is this sufficient for the plant and machinery to be caught by a fixed charge? Does your answer change if the charge document stipulates that the assets cannot be sold without the charge holder's consent? Yeah, now this is again, this is another really good question, because the word fixed can mean two different things, and well, it can mean lots of different things, but in the context of looking at plant and equipment, fixed can mean fixed as in the sense of bolted to the floor, or too big and heavy to move easily. So you're looking at something which is dripping oil and powered by steam, for example, as opposed to computer on a dongle that just plugs into the back of a computer. But I don't think that's the important use of the word fixed in terms of looking at whether you've got a fixed charge or a floating charge. To my mind, you go back to the Yorkshire Woolcombers test about having this category of asset where the class is continually changing over time. And I think that's the distinction between something like stock, which is going to be coming and going all the time and is going to be a current asset, and plant and machinery, which is going to be a fixed asset in the company's balance sheet. It's not coming and going. And something like a computer on a memory stick, I mean, it may be just something that size, but nevertheless, that's something which is going to be in most businesses is going to be bought as a piece of fixed plant, and is going to be depreciated over maybe 3 years, maybe 5 years, and it'll be chucked out when it's got to the end of its life. That was all recognised in the Avanti debenture, where the covenants recognised that worn out and obsolete kit could be chucked out and replaced without needing the lender's consent. And I think, again, many bank debentures will allow that. So I think if it's plant and machinery and it's in the company's balance sheet as a fixed asset, you need to look at what the debenture says. And if the debenture claims a fixed charge on it, and if the debenture contains some sensible contractual restrictions on what the company can do with that fixed plant, then I think you may well have a fixed charge on that plant and machinery. And yes, I know this is an important point, because this is reducing the uncharged assets available for paying the expenses of a liquidation. And I think this is actually quite a significant point from Avanti. So I hope that's helpful. Next question is from Neil Stewart. Thank you, Neil. Another really good question. This is about a charge on book debts. And Neil says, what if a debenture purports to create a fixed charge on book debts? It requires the proceeds to be paid into a blocked account, but in reality, that is not how it works. Is the fixed charge creation necessarily a sham? And this is going back to Brumark Spectrum Plus, where the Privy Council and House of Lords said that, yes, it would be possible to set up a fixed charge on book debts, but the money would have to be paid into a blocked account so that the company is not free to use it. And I think it's pretty clear from Avanti that if you do set up an arrangement of that sort where there is a blocked account, contractually a blocked account is intended to be set up, but from day one you've never actually run that blocked account, then I think you've got a floating charge. And if you subsequently impose a blocked account, what you're doing is you're crystallizing a floating charge into a fixed charge. But if in reality you have been running a blocked account from day one, then I think you would have a fixed charge. So I think this is one of those situations where it is not just the contractual terms itself that determines whether it's a fixed or a floating charge, but it is actually the way that the relationship is operated between lender and borrower. So yeah, I think in a case like that, I would regard blocking the account as being crystallization if it was not done from the very outset. I have to say I'm not entirely sure what is meant by a blocked account in the language that was used in Brumark and Spectrum Plus. And I think that's something that, again, you'd have to look at quite closely. And I think you'd actually have to not just set up a blocked account, but you actually have to use the language of a blocked account as well. So Neil, I hope that's helpful for you. And I just see there's a supplementary there. Yes, well, Neil is saying, do you actually have to show that the fixed charge is a sham to classify the charge as floating? I don't think you have to go as far as to show that the fixed charge is a sham. I think the distinction between a fixed charge and a floating charge is this question of control. And although you could assert sufficient control by having contractual terms for a blocked account, in reality, that wouldn't be enough control unless you actually blocked the account. And as I say, I think it would then turn upon when you blocked the account. And if it was blocked from day one, it would be a fixed charge. If it was blocked from day two, then it would have been a floating charge on day one and then crystallized into a fixed charge on day two. So Jeremy Knight has asked a question. The question is, does a generic phrase such as fixed and generic wording such as floating charge over all assets sufficient to be fixed on assets if not sufficiently listed? Yes, I think, as I understand this question, Jeremy, you're asking whether it is possible to have a fixed charge on a class of assets. And yes, it is possible to have a fixed charge on a class of assets. So typically a bank debenture will have, say, clause 3 is usually the charging clause, and the first item in clause 3 is usually a legal mortgage on land that is identified in the debenture. Secondly will be a legal mortgage on all other land that the company owns. And the third one will be a fixed charge on all land that the company might acquire at any time in the future. And the first one is a specific fixed charge on land that is identified. That is clearly going to be a fixed charge, and if registered at the land registry, and if the debenture complies with the right formalities, would actually constitute a legal mortgage. The second one, a fixed charge over all land that the company owns, that is going to be a charge over a class of asset, and that is potentially going to be enough to create a valid fixed charge over all land that the company owns at the time when it signs the debenture. It will depend upon the debenture containing covenants that restrict the company from selling that land without the lender's consent, and there will be the option there for the lender to register the debenture against all of those pieces of land, even though it may well be that the intention is at the outset that that should not happen. Registration of the debenture at the land registry against each piece of land would effectively upgrade the charge from a fixed equitable charge into a fixed legal charge. But there is no reason why you should not have a fixed equitable charge over all land that the company owns. And the third part of that charging clause would be a charge over all land that the company may acquire at any time in the future. And again, that could certainly be a valid equitable charge on all land that the company acquires after the date of the debenture. Again, you would need to have covenants in the debenture to give the bank control, but I think those covenants would be sufficient. So the answer to your question is yes, a charge claimed as a fixed charge over a class of assets can certainly be a valid fixed charge over the assets in that class, both present and future, but it will depend upon having sufficient covenants and in some cases other arrangements between the lender and the borrower to ensure that it is a valid fixed charge and not a floating charge. And I think that seems to be all of the questions that I have got. So at that point, if there are no more questions, I will say thank you all very much for listening. Give you some dates for the diary for the future. The first one of those is the date of the next coffee break briefing, which is Monday the 5th of February. And I'll then be talking about section 423, transactions defrauding creditors. And because I like talking about old cases, I'll be talking about the case of Midland Bank and Wyatt, which is an old case and is still a really good case for showing how section 423 works and does seem to be frequently cited in section 423 cases that come to court. 3 days after that, on Thursday the 8th of February, is the date of the next regional R3 quarterly meeting, and that's going to be at a venue near Southampton. There will be details coming out from R3 about that in the next few days. I'll be giving one of 3 presentations. There'll be a couple of lawyers from other firms giving other short presentations, and I'll be talking about the implications of HMRC's decision to stop giving clearance to close MVLs and other cases. I'm just looking to see if there's another question come in. Then we've got the date of Threaten's 3rd annual insolvency conference, which is going to be early June next year. Venue and exact date yet to be confirmed, and I can give you the dates and the likely dates for the SESCA, the likely seminars and conference this year. That's if you want to make a note of those in your diary. It's likely to be the spring seminar on the 23rd of May at Denby's Wine Estate near Dorking. The 2-day conference will be at Reading University, 12th to 13th of September, and the autumn seminar will be at Denby's on the 10th of October. And final slide is my mugshot, contact details, and my colleague Harvey Pavey, who many of you would have encountered working with me. And with that, I will say thank you all very much and goodbye, and see you again in 4 weeks' time, if not before. Thank you all very much.